Hey guys, it's Kathy. I hope you're doing well. As promised, today we're just going to do two habeas hearings in Georgia. And the accents are wonderful, unbelievably great. And it's their per se because, well, the one guy has a lawyer, I guess. Just didn't show up because I don't know if he knows he's a lawyer. I don't know. But the other guy has a problem with his lawyer. So these people have already been through the process. They've been arraigned, pre-trial. They took pleas. They're in jail. It's all over. But now they're going back and saying, wait a second, that's not right. I shouldn't be in jail. My plea was wrong or whatever. And now their trials are for this. And we don't have answers at the end of this. They're just two hearings. Um, let's just get started.
That was made between the prosecutor and the defendant.
Yes, sir, that is correct. That's the one.
All right. Do you recall that there were several plea offers made by the prosecutor well before trial?
Yes, sir.
And do you remember that the last offer was 25 due 8, which was made on 27th of April, 2017?
You're correct on that. I read that again last night.
Okay. And Gracie Lane was assigned to the case during July 2017.
Okay.
Which was granted.
I don't recall that specifically, but I think you may be right.
Okay. And you raised on your direct appeal that the trial judge erred in not granting Lane motion for continuance.
Yes, sir.
Okay.
I mean, although, he's the judge, he can pretty much do what he wants within the bounds of the law, which that was. But, he doesn't have to.
Okay. Do you recall in your thorough review that when the court denied the motion to continuance, I informed Lane and the judge that I would accept the plea offer?
Yes.
Okay. The court refused to accept the plea offer, isn't that correct?
Yes.
Are you aware of the fact that Lane never explained to me that the trial judge had a policy that he would not accept a negotiated plea on the first day of a trial?
I guess I thought you already asked that, but yeah, yes.
Considering Mr. Lane had the case approximately 4 months prior to the trial, wouldn't you agree that this is something he should have explained to me? The trial court's policy on plea offers?
Absolutely. He has a duty to tell you everything he knows about everything about the case. Can't hold anything from you.
And do you recall that I had to address the courts on all these matters?
I believe you did. Yes, sir.
Do you remember me informing the court that neither Lane or myself was ready for a trial, that I had not received all of my discovery, nor had I been able to view the videos of the robberies?
I recall that.
All right. Do you also recall me informing the courts that Lane had not been to see me to go over the defense, and that when I questioned him about this, he cussed me out?
Yeah, I think I recall him cussing you out.
Okay. And am I correct in stating that you raised on your direct appeal that the trial court erred in not accepting the negotiated plea offer on the first day of trial?
Yes.
Mr. Allen, if that's the judge policy and it's not required by law, how is that an error?
There was a good faith basis for that. Like I said a couple dozen times already, the judge has a lot of latitude, and you know, I can't say it any more than I've said it. I mean,
Okay. Like I said, Mr. Allen, I stated earlier I'm not an attorney like you, but isn't it true that this plea deal situation all reverts back to the fact that Lane never explained to me what Judge Lane's policy was on accepted pleas?
yeah, I think we've been over that. I think I've responded to that a bunch of times. I mean, can you kind of get to the point? I'm not going to rush you, but I mean, it's just nothing. Never mind.
Wouldn't you agree that this was information that should have been given to me early on by Lane so I can make an informed decision on how to proceed?
Yes.
Do you recall in your brief of appellate to the Georgia Court of Appeals on the issue where discussing that you didn't cite any case law or controlling authority to support your claim?
I don't recall that, but if the record reflects that, it's true.
Okay. Mr. Allen, do you also recall in that same brief on the same issue, which is at page 13, where you stated that the policy disregard the motion of the judicial economy of avoiding an appeal of the clearly inadmissible Smith testimony?
Sure.
Okay. This is the reference to the Angie Smith testimony where Lane was surprised and moved for a mistrial as opposed to objecting first. Is that correct?
Repeat it.
I said this is reference to the Angie Smith testimony where Lane was surprised and moved for a mistrial as opposed to objecting first. Is that correct?
Sure.
If Smith's testimony was clearly inadmissible, as you put it, why didn't you raise it on direct appeal, or did you somehow miss it?
The record reflects what I did, okay? If you go back and read my brief, there is a citation of cases at the end. Every case I cited. Have you read them? You read all the cases I cited?
I've seen those cases.
Did you read the cases?
I read the cases, not all, but I'm limited to reading. I read everything you had, but I'm limited to getting to certain areas as far as cases and stuff because the library is hard to get in there.
Well, you've got to be able to read each one of the cases, okay, before you can discuss that issue.
Okay. If Smith's name was nowhere to be found, hypothetically, and the government simply snuck her in somehow, wouldn't that be a serious discovery violation on the part of the prosecutor? Sir?
I don't speak in hypotheticals.
Okay. Well, what was your opinion to that then?
My opinion to what?
I said somehow if she was snuck in, wouldn't that be a serious discovery violation on the part of the
I'm
prosecution?
going to object. That calls for speculation.
Mr. Anderson, Mr. Daniels has objected and says your question calls for speculation on the part of the witness. You have a response to that objection, Mr. Anderson?
Yeah, I mean, I'm just asking, what is it a violation? So I'm not incorrect. I'm not correct for asking, is that a violation or a serious discovery violation on the prosecution? I can't answer that. Ask that kind of question.
I'll overrule the objection. I don't recall if you've asked that specific question before, but you've gotten very close to it. But you're starting to repeat
Okay.
yourself, Mr. Anderson. But I think you're right about that. I don't think you asked Mr. Allen that specific question. So, Mr. Allen, I'm going to allow you to answer the question about the discovery violation, if you know.
What's the question about the discovery violation?
I said that somehow, well, you said you don't deal it hypothetically. So I was asking, is it somehow they snuck Angie in as a witness? She was already interviewed one time. Then at the very end of, the beginning of the trial, they brought her in.
Well,
I
now,
guess.
hold on, Mr. Anderson. Now,
Yes, you are wearing me down, I guess.
hold on, Mr. Allen. All right, Mr. Anderson, I think you changed the question. The original question was, does the witness know if that's a discovery violation? So that's the question.
Yes. You want me to, I'll just start over I'm just gonna read what I got written down. I say, if Miss Smith's name was nowhere to be found, I'm gonna skip the hypothetical because you don't do that. And the government simply snuck her in somehow, wouldn't that be a serious discovery violation on the part of the prosecution?
Sure, why not?
That's all I said. Thank you.
He's done with the questions. He doesn't care anymore.
Considering you stated that Smith's testimony was clearly inadmissible and that Lane did an incredible job, why didn't you raise the Smith issue under the prosecutor misconduct for failure to turn over the information to Lane in some kind of timely manner?
I don't know.
Okay. You don't know. You did say you read the trial transcripts on this aspect of the case, right?
What did you say?
I said you did say you said you read all the transcripts on this
Yes,
aspect.
I read every page of the transcript.
Okay. Did you recall reading where the district attorney ejected Jackie Johnson came out of the galley during the Angie Smith argument and basically begged the Judge Lane to accept the state's plea offer of the 40 do 10 or 15?
What?
You remember that?
You need to stop, okay? I have had enough. You need to stop. Judge, please, make him stop.
Well, Mr. Allen, I can't see you anymore. Are you back in front of the camera?
I'm sorry,
Sir?
Can you see me now?
Are you having some physical difficulty, Mr. Allen?
I'm fine. Just please, let's go. Let's do it. Let's do it.
I can't hear you, Mr. Allen. Can you get a little closer to your microphone? I can't quite hear what you're saying.
Can you hear me now?
a little bit better.
He's a lawyer.
All right, Mr. Anderson,
Yes, sir.
you may proceed.
All right. Should I read this question again or should I go over? Because he said stop, and I'm just reading some of the stuff that I've studied. I'm trying to.
Well, I forgot.
So what?
I have forgotten the question myself, Mr. Anderson, so maybe you need to repeat it.
Okay. I said, you don't recall reading where the district attorney-elect Jackie Johnson came out of the galley during the Angie Smith argument and basically begged Judge Lang to accept the state's plea offer of 40 do 10.
Judge, I'm going to object. That question even starts with the proposition that he's already answered it and said that he doesn't recall. So Mr. Anderson essentially has asked a question that he already has the answer to, and he's not entitled to just badger a witness.
Well, you kind of gotten me confused by the question as well, Mr. Anderson. If you're, I don't know, see, as I understand it, Mr. Allen was not the trial attorney, he's the appellate attorney.
All right.
So.
But go ahead. I'm sorry, Your Honor. I'm sorry. My apology.
All right. So, anyway, I don't know that if I understand what Mr. Allen is trying to say, he doesn't know, I think is what he's trying to say, but.
Well, Your Honor, all I'm doing is, I'm not an attorney. I'm doing the best I can. It may be some things I may not know. Technically, I don't know, but these are stuff that I been trying to read and study to help myself. I'm sure I'm upset, but I'm not that upset to where I'm gonna, just get all argumentative with anyone. I'm just trying to figure out stuff myself. And what I'm reading is in the transcript, in which Mr. Allen said he read everything, so he might have just forgot. Well, he might have just, because if he read the he might have forgot. It's a lot. I got a pretty thick transcript, so it might have been something he read that he might have forgot. But this is everything I'm reading is basically in the transcript, so I'm not making anything up. This actually happened.
Judge, in further support of my objection, if it's in the transcript, there's no point in him asking a question about it. The transcript being admitted to evidence is going to speak for itself.
Well, Mr. Anderson, we got to get through this, and
okay.
If it's in the transcript, it's in the transcript, and asking the witness over and over and again if he remembers what's in the transcript, well, at some point, we're just wasting time. But Mr. Anderson, you need to tailor your questions to what this witness has to offer in support of your application for writ of habeas corpus, and asking the witness question after question after question about what's in the transcript is not going to help me make a decision on your claim. So anyway, you can proceed, Mr. Anderson. Let's get through this.
Okay. Let's see.
All right, Mr. Anderson, do you have any more questions for Mr. Allen?
Yeah, I have some more questions, but what you're saying is I'm trying to look through them and tell them, because you're telling me that the things that I should be saying should be basically got to do with my Hague. Okay, so that's why I'm scrolling down. I got a few more, but I'm just gonna.
It's a train wreck. A train wreck.
Well, Mr. Anderson, we have to proceed, Mr. Anderson. I'm not going to sit here and let you just read through some list of questions that somebody gave you. I mean, we got to move, Mr. Anderson. So what's your next question?
All right. Let's see. I'll go with this one. Former prosecutor misconduct, recognizing that Lane clearly.
Mr. Anderson, now, I'm very patient, but I don't have time to just sit here and let you read off a sheet of what questions you're going to ask. You've got to ask a question, and we've got to move on, or either I'm going to cut you off. So are you ready to
Okay.
ask the question or not?
Okay. Well, let me ask this. You recall the brief of your appellate grounds where you raised an ineffective claim against Lane because the court denied the motion for continuance?
I believe that's been asked and answered, hasn't it, Mr. Daniels?
I believe it has, Judge.
There we go.
Yeah. Okay. Isn't it also true that Lane cited his reason for needing a continuance was because the case got dumped on him and had
Judge,
20
I'm going to object. That has, in fact, been asked and
Mr.
answered.
Anderson, you're repeating yourself. You asked
Okay.
all those questions at the very beginning, and they were perfectly valid, but I don't need to hear it
Okay.
again.
Okay. Let's see, familiar with the circumstances. Okay. Okay, are you familiar with the cumulative effect of multiple errors by trial counsel?
Sure.
Mr. Allen, are you there?
I'm here, sir. Yes, sir, I'm here.
I can't hear you, Mr. Allen. Can you speak up?
Speaker again. Can you hear me now? Can you hear me now? What else I can do? I'm speaking.
I can't make out what you're saying, Mr. Allen.
I'm speaking, and I'm speaking the best I can. I don't know what else I can do. I just,
I understand that.
I'm,
Well, Mr. Anderson, apparently the witness doesn't understand your question, so
I just asked, are you familiar with the effect of multiple errors by a trial counselor?
yes.
Okay. I'm gonna get through. I'm gonna ask. I only got a few more. I'm just gonna skip some of them because this is not. I don't know. Do you recall that we discussed today's Lane failure to fully review the state's discovery, which he admitted to, failure to object to the testimony of Angie Smith before she started testifying, failure to explain to me the plea policy that Judge Lane Court.
Judge, I'm going to object. Number one, all of those things have been discussed in other questions already. He's trying to summarize Mr. Allen's testimony and essentially testify through asking questions, and it's improper for several reasons.
well, Mr. Anderson, you've asked all that before. I mean, I got it. I understand. I heard it the first
Okay.
time and I
You see-
understood it. So you've asked that
Okay.
question already, Mr. Anderson. So let's move on.
Okay. All right, let me ask this. And let me ask you this. Is it true that, equally true that on occasions an appellate lawyer will miss or maybe rule out the stronger grounds in favor of some weaker issue?
I'm trying to find out where to, how to get to the,
What I was saying, you heard that, what I said?
All right, Mr. Anderson, you have any more questions?
Yeah, I just read one. I
don't know how to get back to that, and we just keep going over and over, and I just don't know how, and you keep saying the same thing. I don't know how.
Well, the question that I have is just only, like I said, I'm not an attorney. These are some of the things that I'm just trying to figure out myself, because I feel that my trial was from what I read, it was a lot of mistakes that could have been prevented. That's all I'm saying. And I have a lot of questions. I understand you're on a time limit, Judge, but I have a lot of questions that waive a lot of issues. And not being prepared, and like you said, you already heard it.
Mr. Anderson,
not being prepared.
hold on, Mr.
Yes.
Anderson. I understand you can make all those arguments to me later, but
Yes, sir.
if I understand, you say you're done with your questions. I'm going to give you a chance to come back to it. But Mr. Daniels, do you have any questions for Mr. Allen?
I do not, Judge.
All right, Mr. Anderson, this is your.
Yes, sir.
I mean, you've asked a lot of the questions the same. You get the same information in a different way, but do you have any more questions for Mr. Allen? Mr. Anderson? It's a
I'm just
simple
reading up.
question. All right.
No, so I just have to try it again, I guess, because like I said, I have questions, but like I said, they all similarly pertain to the same thing, but then in a way they don't, because I'm trying to figure out exactly how everything went, because what I read.
All right, Mr. Anderson, I understand. All right, Mr. Allen, thank you for your time, sir. You are excused and you're free to go about your business. You can disconnect
Thank you. Goodbye.
the connection. Thank you, sir. All right, Mr. Anderson, do you have any other witnesses or do you wish to testify yourself?
No, I don't have any other witnesses. I just wanted to speak to Mr. Allen really about what I was, the information that I was trying to read and find out because of my case. I don't know I don't know much about this. I don't even know nothing about Habeas. I don't know exactly what a Habeas is besides the time
Mr.
release.
Anderson, hold on, take a breath. I understand. I'm not fussing at you, Mr. Anderson.
Okay.
All I'm trying to tell you is that you did a good job, but you're covering the same ground, and I got it the first time. I don't need to hear
Yes,
it
sir.
6 and 8
Yes,
and
sir.
12 times. I got it. All right.
Yes.
I understand what you're trying to say, but we got to move on, Mr. Anderson. Do you wish to
Yes, sir.
testify yourself? Yes or no?
Testify. Okay, can I ask you a question?
No, sir. Do you wish
Okay.
to testify or not? Yes or no?
I guess I could testify on my own. I guess I don't know. I mean, I don't know. That's my first time.
I understand that, Mr. Anderson. Well, you got to tell me something, Mr. Anderson, or either I'm going to cut you off because I got to move on. So, do you wish to testify or not? Yes or no?
Okay, I'll testify.
All right, raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give in this case shall be the truth?
Yes, sir.
All right, Mr. Anderson. Now, like I said before, you're going to get a chance to make any argument that you want to make later. When you testify, you're going to be subject to being cross-examined by Mr. Daniels. So, all right, Mr. Anderson.
Okay. That's why I was trying to ask you. So I have to make a brief after this. Then I can come back.
Yes, you.
Okay, that's fine. I don't know. That's why I asked you, Your Honor, because I've never been to this.
I understand.
I don't know nothing about it. So I could wait and get myself together because I'm new to this. It's my first time, so I guess I can wait.
Okay.
And I try.
I understand, Mr. Anderson. All right, I take all this to mean you now do not wish to testify. Do you have any exhibits, documents that you wish to submit, Mr. Anderson?
You asking me this?
Well,
You asking me?
hold on just a second here. Mr. Daniels, I should have said this at the very beginning. Mr. Daniels usually has a complete copy of your entire transcript and record from your trial, and he usually submits that into evidence. And of course, you will be provided with a complete copy of all of that after we get through today, and you can refer to it in your closing brief. Does that make sense to you, Mr. Anderson?
Yes, sir. Yes, sir.
All right, so you'll get the chance to argue about any record citations you want to make to bring to my attention. So, all right, Mr. Daniels, you ready to proceed?
Yes, Your Honor.
All right, go ahead.
We have Respondent's Exhibit A, which is a copy of the briefs and the Georgia Court of Appeals, as well as the trial court records.
All right, did you understand all that, Mr. Anderson?
Yes, sir.
And Mr. Daniels will submit that to the court, and then once all that gets submitted, and a transcript of today's proceeding will be prepared, filed in, and hand-delivered to you, a hard paper copy of all of this, and then you will have a period of 30 days to file any written objection or written response that you care to make, and make all the record citations that you feel appropriate. Do you understand all that, Mr. Anderson?
Yes, sir.
Do you have any questions about this process?
No, sir.
All right, very good. Anything else from the respondent, Mr. Daniels?
No, Your Honor.
All right, Mr. Anderson, that will conclude this case for today. You'll get your copy in due course, hand-delivered to you, and I look forward to receiving the brief that you already refused, Mr. Anderson.
Thank you.
The record, this is position number 3 on our calendar. You are William Clark.
Yes, sir.
All right, Mr. Clark, I have just a couple of announcements I want to make here before we get started. First of all, Mr. Clark appears today from Telfair State Prison via our video platform WebEx. Mr. Clark, can you see me and hear me okay?
Yes, sir.
All right, excellent. My name is Judge Mike Johnson. I'm presiding today from the Telfair County Courthouse. I have present with me here the clerk of court and the court reporter. Also appearing via WebEx is Mr. Ron Daniels, representing the respondent. Mr. Daniels, can you see and hear everyone okay?
Yes, Your Honor.
And Mr. Clark, can you see and hear Mr. Daniels?
Yes, sir.
All right, very well. Today is down for I believe it is an evidentiary hearing. Is that correct, Mr. Daniels?
Yes, Your Honor.
And Mr. Clark, an evidentiary hearing is your opportunity to present whatever testimony, documents, or exhibits that you contend is in support of your application for writ of habeas corpus. Are you prepared to proceed today, Mr. Clark?
No, sir, because my lawyer is not present.
Who is your lawyer?
Justin McCall.
I don't know.
Justin McCarroll.
Give me the name one more time.
Justin McCarroll. I mistaken it with MCCARAL, like Justin McCarroll.
I don't know anything about that, Mr. Clark. Mr. Daniels, have you heard from this person?
No, Your Honor.
Well, Mr. Clark, there's no record in the file of anyone entering this case as your attorney. The last thing I see in here is a written request from you filed in on February 14th for a subpoena for Ms. Jefferson, and I see Ms. Jefferson is logged in and standing by. But that's the last thing in the file. I've not heard from any attorney, Mr. Clark. What do you say about that?
He been coming to see me, and he had me sign some papers saying that he was going to be representing me at my habeas corpus. Like, I don't have his envelope up here right now, but I got it back in the dorm or whatever. His name is Justin McCall. Yeah, and he came up. He came and visit me up here like 4 times. He was letting me know that he was taking on my case, and he had me sign some papers saying that I gave him permission to represent me for my habeas corpus. So.
And where is Mr. you said
McCarroll, it's Justin McCarroll.
And where is he from?
I would have to look at the envelope. I don't have the envelope up here with me because I thought he was going to be here, sir. But
Judge, if I could just add in, Justin McCarroll works for the Georgia Resource Center. And he, actually, we've had some conversations regarding Mr. Clark's case. He contacted me regarding some documents that he needed. But as far as I know, he works for the Georgia Resource Center.
Well, all that's fine and good, and I'm not trying to be hostile, but this case was scheduled, I believe I signed an order setting dated February 2nd, filed in on February 2nd, setting this matter down for today. And I've not heard from anyone. I don't see anything in the file. I'm at a loss, Mr. Clark, to explain any of this, and the clerk is sitting right here with me, and she's not received anything whatsoever from anybody claiming to represent you, Mr. Clark.
I'm really confused and like, I was told that I was told by him that he was gonna be here with me or whatever. That's my first time, and I don't know. I'm confused right now.
Well, I'm not particularly hostile to your case, Mr. Clark. I mean, it's getting a little age on it, but I mean, it's not terrible, so I'm not fussing at you. This appears to be the first time on the calendar. Is that your recollection, Mr. Daniels?
It is, Your Honor, and I'm not necessarily opposed to continuing it, but I do think that Mr. Clark should put on the record when he last spoke to Mr. McCarroll, the date or approximate date of when he believes that he agreed to represent him, because, I mean, it's 3 weeks ago or a month ago, Mr. Clark himself requested subpoenas, they say. Back in January of this year, he amended his habeas corpus petition. So if Mr. McCarroll has been retained or agreed to represent him, then we need to know when, because obviously there's obligations under Uniform Superior Court rules for somebody to enter an appearance and things of that nature.
All right. Well, Mr. Clark, again, I'm not fussing at you, and I'm not being hostile to you, but this is really, well, I need an answer on is this man representing you or not, and I'm going to give you the chance to get it resolved. When is our next regularly scheduled day, Mr. Daniels?
Judges, in April, it is the 23rd. However, we are setting them in the afternoon for 1:30.
Oh, that's right. Yeah, you did mention that to me at 1:30. Do you know yet, Mr. Daniels, how many are scheduled?
I believe we have at most 3 scheduled, and that includes some motion to dismiss.
All right, well, Mr. Clark, it doesn't, let me choose my words carefully. It appears that you have done what you're supposed to do and that this other person has not done what they're supposed to do. So I am going to continue this case off of today's calendar, and I am going to give you until April 23rd. And no, let me say, no, again, I'm choosing my words carefully. I am rescheduling this case for April the 23rd, and we are going to have a hearing on April 23rd, whether you have a lawyer or not. Do you understand that, Mr. Clark?
Yes, sir. I understand that clearly.
So you can tell this person that the judge said, don't come asking me for another continuance. It's going to go one way or the other on April the 23rd. I don't know how to be more clear than that, Mr. Clark. Do you understand that?
Yes, sir. I fully understand.
All right, Mr. Daniels, get me an order. And Mr. Clark, you can also tell this gentleman that I expect him to get an entry of appearance filed, and I mean as soon as possible. You understand that, Mr. Clark?
Yes, sir.
All right, very good. I'm going to excuse you for today, Mr. Clark, and I'm going to see you again on April 23rd.
Yes, sir.
All right, and Ms. Jefferson, is that right?
Yes, Your Honor.
You are still under subpoena. Mr. Daniels will notify you as soon as you notice, but you're still under subpoena, and I'll see you again on April 23rd as well, Ms. Jefferson.
Yes, Your Honor. Thank you.
All right, you are excused, Ms. Jefferson. Thank you.
Thank you.
Uh-oh, I left dead air in here. That was my bad. I'm just making this bigger for
All
a
right, so the
second.
record
Oh, there we go.
Next is position number 2 on our calendar, 23CH022. Justin, pronounce your last name for me, sir.
Hush,
All right, one more time. I can't hear you, sir. Something's wrong with your.
Hush.
All right, well, I can hear you, but just barely. Let me see if I can get a little more volume here. No, it's all maxed out. Seems to be anyway. All right, you are Justin, is it Hosh or Hosh?
Whoosh.
I can't hear you, sir. Something wrong with your button, or you're either supposed to hold it or let it go or something. I don't know, but I can't hear you.
Don't worry, they fix it.
All right, can you hear me now, sir?
I hear you now. Yes, sir.
Okay, it's Hush.
Hush. All right, Mr. Hush, I have your application for writ of habeas corpus here in front of me. Is this an evidentiary hearing, Mr. Daniels?
Yes, Your Honor.
All right, Mr. Hush, I have some preliminary matters to go over with you first. First of all, my name is Judge Mike Johnson. I am presiding today from the Telfair County Courthouse. Mr. Hush appears to us from Telfair State Prison via our video platform WebEx. Can you see me and hear me okay, sir?
Sure.
All right, very good. As I stated a moment ago, this is the evidentiary hearing. Representing the respondent is Mr. Ron Daniels. Mr. Daniels, can you see and hear everyone sufficiently this morning?
Yes, Your Honor.
All right, and Mr. Hush, can you see and hear Mr. Daniels? Well, again, that button seems to be tripping us up, sir. I didn't hear your response, so just try.
I think he's got I think you have to press it down the entire time you're talking. It is sort of what I'm picking up on.
All right, well, I haven't really been paying attention, but let's try this again, Mr. Hush. I'm having trouble picking up your audio, but can you see and hear Mr. Daniels? Is there someone out there at Telfair State Prison can help Mr. Hush figure this out? 'Cause
Probably
I
not.
can't hear him.
This guy's a little sad when he starts talking.
Well, while he has stepped away, we also have apparently logged in Mr. David Whitman. Mr. Whitman, can you see and hear everyone okay?
Yes, sir.
Excellent. All right.
Speak now.
Can you hear me?
I can now, yes, sir. And if that's a microphone, you need to pull it up a little bit closer because it's very faint. All right, how about now, Mr. Hush? Let's try all this again. Let me see if I can hear you this time. Go ahead.
Hush, yes, sir.
there we
Can you
go.
hear me now, sir?
All right, and we also have Rebecca Wyatt logged in. Who is she attached to, Mr. Daniels?
That's my paralegal judge.
Oh, okay. I'm sorry. I wasn't paying attention. All right. Mr. Hush, I have some just general announcements for you. This is the evidentiary hearing on your application for writ of habeas corpus. This is the opportunity for you to present whatever evidence, testimony, or exhibits that you contend are in support of your application for writ of habeas corpus. You had stepped away just a moment ago, and we have Mr. David Whitman is also logged in as a witness. He is standing by. Are you ready to proceed with your evidentiary hearing, Mr. Hush?
Sir, last month, my last scheduled evidentiary hearing, I had went and had surgery the day before. I think I was at Coastal State Prison, so I went along with all my legal material once again. And once they shipped me back after surgery, like I still haven't got any of my documents back. I'm still waiting. And I was scheduled for court one day before my surgery. So it's like I took all my property once again, and it still hasn't got returned to me.
And how long have you been back at Telfair now?
About a month, 3 weeks. I say 3 weeks to a month.
Gosh, I think we've tried to schedule this thing multiple times already, hadn't we, Mr. Daniels?
Yes, Your Honor, and I believe last time you indicated that you were, because this one was pending before it got transferred to Telfair, that you were, this was essentially the last setting of this. I don't think you necessarily put it in an order to that effect, but that you were wanting to get it scheduled and heard.
Yes, let's see. This originally transferred from another county and was filed in Telfair. Let's see. On July 5th, 2023. And following the matter being filed into Telfair County, if I'm reading all this correctly, it was initially scheduled for an evidentiary hearing on December the 20th. And I don't have all of my notes from all these other days. I'm just going through the record here. It was originally scheduled for a hearing on December the 20th, 2023. It's rescheduled again on January 26, 2024. And rescheduled again for today by order dated February the 2nd, setting it down for the hearing. When did you have your surgery? You said surgery, Mr. Hush, is that correct?
Yes, sir. Yes, sir. It was around 3 weeks ago.
2 weeks ago.
Around 3 weeks ago, if I'm not mistaken. If not longer, it could have been longer. I'm not sure.
All right, well, let me get a couple other things on the record here. We have Mr. Whitman standing by. I don't know if he had appeared at any of the previous attempts to have your case heard. Let me ask you just some questions here, Mr. Hush. Do you intend to ask any questions of Mr. Whitman?
Yeah, I think so. I think so.
Are you telling me you're not able to proceed without having your paperwork?
No, sir. I don't have anything.
Well, I understand you don't have anything, but what, do you have all your questions written out or something?
Yes, sir. My questions, my briefings, who all I needed to talk to, like everything pertaining to my habeas, I had brought it with me to Coastal State Prison. And I don't have anything, sir.
All right, Mr. Daniels, what's the respondent's position on Mr. Hush's request for another continuance?
Your Honor, this has been pending, and I would like to at least take the testimony of Mr. Whitman. He is a busy trial lawyer. In fact, today he was on, I think, at least 2 trial calendars, and we were lucky to get him here this morning after those resolved out. So, or the logistics were figured out on that. So I would like to get his testimony if we could. I don't know what sort of questions that Mr. Hosh could have written out for Mr. Whitman that wouldn't be something that he'd be able to ascertain just based off the allegations he's made in this case. It's not a lengthy habeas application, so I don't know that there's too terribly many questions he could have to have for Mr. Whitman, particularly in light of the fact that this was it's not that old of a case. It is an older case, but it's been pending since 2019 at this point. So I would like to go ahead and try to get it done if we could.
All right, give me just a second.
And I should say, Judge, too, that it's also a guilty plea case. And so I don't know there's too terribly many questions that could be there for Mr. Whitman by Mr. Hosh. That, yeah.
All right, well, here's what we're going to do. Mr. Hosh, this is just a complicated mess, and I'm not fussing at you, Mr. Hosh. I mean, it's not your fault. The paperwork hadn't been forwarded back to you, and I understand that, but we've imposed on Mr. Whitman quite a lot. So here's what we're going to do. Did you subpoena Mr. Whitman, Mr. Daniels?
I did, Your Honor.
All right, so here's what we're going to do. We're going to take Mr. Whitman out of turn. I'm going to get his testimony. And Mr. Hosh, I don't know much about your case. I will state for the record that I have reviewed your petition. And if I understand this correctly, this was a plea, a guilty plea, and that Mr. Whitman was your trial attorney who represented you during the plea. It's not an appellate case, as I understand it. So I'm going to give you the opportunity, Mr. Hosh, to listen to the questions that Mr. Daniels asked Mr. Whitman, and then you can follow up with your own questions. And if we need to recall Mr. Whitman, well, we'll cross that bridge when we get to it at a later date. But we've imposed on Mr. Whitman enough. I can't balance all these interests out. It's not your fault. It's not my fault. It's not anybody's fault, but it's certainly not Mr. Whitman's fault. So we're going to proceed as best we can, and we'll try to clean it up at a later date. So, Mr. Daniels, go ahead and swear in Mr. Whitman, and then you can ask him your questions. And then, Mr. Hosh, if you have any questions, you can ask Mr. Whitman your questions. So let's proceed that way. Go ahead, Mr. Daniels.
You swear affirm testimony and evidence you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And would you state your name for the record?
David Whitman, W-H-I-T-M-A-N.
And how are you employed?
I'm a lawyer.
And where'd you go to law school?
Emory,
And when did you become a member of the Georgia Bar?
May 1983.
Have you been a member in good standing since you joined the bar?
Yes, sir.
And can you give me the general nature of your practice since you became a member of the bar?
Yes, after I graduated from law school in 1983, I went to work for the district attorney's office in Lookout Mountain. I spent 4 years up there. That is a 4-county multi-county circuit in northwest Georgia, the extreme northwest Georgia. After I left the DA's office in 1991, I did insurance defense in Atlanta for 4 years. In 1991, July of 1991, I opened my office in Lawrenceville, Georgia. At the beginning of that practice, it was probably 50-50 civil and criminal. It gradually became more criminal. In the last 10 to 15 years, probably all of the criminal cases I've tried, or at least 95% of them, would involve homicide, sex offenses, or some kind of armed robbery charges. Is that sufficient?
Yes, sir.
Okay.
Is part of your work as a, well, let me ask it this way. Do you take appointed cases from Gwinnett County?
Yes, sir. Yes, sir.
And Gwinnett County does not have the opt-in public defender's office. They run their own instead.
Yes, sir.
And as I understand it, there are categories for severity of crimes that you can be appointed to cases on.
Yes, sir. There are 4 categories, A, B, C, and D, A being the highest. I was A. I was at one time death qualified.
Do you know how many felony criminal trials you've handled?
Between 300 to 600 is an approximation.
How did you come to represent the petitioner?
He was initially represented by an attorney named Tom Clegg. He filed a bar complaint against Mr. Clegg. Judge Hamill appointed me to replace Mr. Clegg.
And at what point in the proceedings did you come into representing him?
It was through arraignment before trial. I couldn't tell you exactly where though.
And you actually proceeded to trial with this case.
Yes, sir. Yes.
And a decision was made during the course of trial to enter a guilty plea.
Yes, sir. At the end of the second day. The decision was discussed the end of the second day. I believe it was the third day that he actually entered a plea.
Had you had the opportunity to meet with him and develop a strategy for trial?
Yes, he represented himself for
Of course he did.
several months. I don't remember how long, but at one point he represented himself. But yes, sir, we talked. I was ready for trial.
Were you able to get a copy of the discovery in the case?
Yes, sir.
Did you have any concerns about whether it was complete or not based upon your review?
No, I wouldn't have gone to trial if I thought there were any problems. And they wouldn't have made me.
And in fact, he went to trial with a co-defendant, is that correct?
No, I don't think so. That's not my recollection. I have here that a co-defendant got life without parole. I don't remember if we had a co-defendant. I mean, this was a while back. I don't recall that. No, sir.
Okay. Do you recall do you recall the circumstances of him deciding to enter a guilty plea?
Vaguely. What I saw in my notes from we're appointed and we submit a bill when we're done with the case. Part of that bill is I prepare a narrative explaining to the committee that pays me why the bill is the way it is. This would be a business record and past recollection recorded. And my notes show that on the second day, Mr. Hush, my quote is, gets real. I asked him to think about it, but it was better than doing the plea then than waiting for a verdict. My recollection is this was a train wreck for him, and there was no way he could win. And he finally realized it was time to take a plea. And so the district attorney asked for 30 years consecutive on the armed robberies. And I asked for 10 on armed robbery with 20 on aggravated assault. And the judge gave him 15. The recommendation before trial was 30 to 20 to armed robbery. This is one of the few cases I've seen where he got less time by going to trial than by entering the plea prior to trial.
Did you go over all the statutory and other questions, constitutional right questions with him before he entered his plea?
I can't tell you from memory, but I have never pled anyone guilty to a crime, misdemeanor or felony, without going through the entire guilty plea monologue with them. And I would have done that in this case because it looks like, as best I can tell, this was a non-negotiated plea. Yes, sir.
And obviously, you won't recall independently, but do you recall that subsequent to him entering his plea that he filed a motion to withdraw his plea?
No.
Okay.
I didn't know that at all.
Okay. That's all the questions I have, Judge.
All right, Mr. Host, based on what you've heard here today, do you have any questions to ask Mr. Whitman at this time?
At this time, I do not, sir.
All right, well, Mr. Whitman, then I'm going to excuse you for today. I don't know what's going to happen next, but we'll cross that bridge when we get there. But thank you for your time, sir. You're free to go about your business, and you may terminate the connection.
Thank you very much, Your Honor. Everyone have a good day.
Thank you, sir. All right. Well, Mr. Daniels, do you think it would be a good idea to get your part admitted at this point, or so we don't have to worry about that?
No, Your Honor, I would rather reserve that until later.
All right. Well, that's what we'll do. Mr. Host, so we had this come up in our last case. Our next regularly scheduled day is April 23rd. Let me make sure of that. Isn't that what I said? Yep, April 23rd. So we will reconvene on April the 23rd. Have you received any communication whatsoever from the administrators about when you'll receive your documents, Mr. Host?
No, sir, I haven't, but I recently grieved the whole situation, so I'm waiting for a reply.
All right. Well, there's just not much I can do about it. I don't like it, but there's nothing I can do about it. So we will reconvene on April 23rd. Get me in order, Mr. Daniels.
Yes, Your Honor.
All right, Mr. Host, that's it for today. You are excused. Thank you, sir.
All right, so thank you.
The patience of a saint that judge has. I felt bad for that last guy because, I mean, he's in jail. He can't just go get paperwork. He's, waiting on everybody else. And, they're not in a hurry. They have no skin in the game whether they get him his paperwork or not. So he just has to sit there and wait. And he didn't have any of his paperwork when they just questioned that attorney, which I did not like at all. So he doesn't get to question him. But I don't know. It was a guilty plea. He pled guilty. So I don't know how well he was going to do anyway. It probably wasn't going to work out for him very well anyway. It's not over, so we don't know what happens on any of these. They're still working on it, but it was just a train wreck day. And this judge pushed it forward. Oh my. Okay, guys, thank you so much for coming out today. I appreciate it. I love my chat. Gosh, you guys are great. Now I'm hungry for Swedish fish and peanut M&Ms to try that. There's always food in my chat. Always. I wonder if we can get through a stream with no food. All right, guys. I will see you next time. Cloud, you have a good day too.